The real estate regulation is now to some extent is codified under the Real Estate Regulation and Development Act 2015, popularly known as RERA. This RERA is a central legislation. The central legislation is made by the Parliament. You know that India is a federation, a union of states, under which both states and the center and the union have defined powers and defined jurisdictions in matters of those subjects, which are as mentioned in 7th schedule. List 1 pertains to the union list, list 2 states list, and list 3 concurrent list. Why I'm saying this? Because you need to know, if you want to understand the real scope of this particular enactment, you need to know and appreciate that the jurisdictions of the state and center in different subjects relating to the real estate. Because the scope of the act, the act will prevail over any other enactment relating to the subjects provided or the matters provided under this act. So it will only prevail to the extent of conflict and to the extent of jurisdiction. If the state, if the union which has passed this legislation has no jurisdiction at all in this subject, on a particular subject, then this act will not have overriding effect. Similarly, this act will have overriding effect only to the extent there is a conflict. To understand this, let us know in a minute what are these jurisdictions or subjects falling into between states, center, and the concurrent. The state land, real estate means land and buildings in the common parlance. It is used in contradistinction to personal properties, personal possessions, that is movables, charges of action, charges in action, etc. So the land, all the matters relating to the land fall within the state list. It is item number 18. Similarly, item number or entry number 25 in the list 2 deals with land tenures, record of rights, etc. Item number 5 of the state list deals with the municipalities, local bodies, development trusts, etc. What is the significance of all this? The significance is, you all know the title to the land, a bare land, an undeveloped land, whether it is an agricultural land or not. You need to know the history of title. The history of title will be known only if you know the land tenures, the law relating to the relations in land, who has got what interest in the particular land, whether as a landlord, as a tenant, or in any other different capacity. So far these, to know the history, you will have to know the land records. From the land records, land survey records, what was the title, what was the history of the title so far as this land is concerned. This is entirely state subject. Record of rights is also entirely state subject. And entry number 5, which deals with the municipalities. you know, if you want to use a particular land or develop land, you need to follow certain laws. What are they? The laws relating to the development zoning regulations. There are two categories of state legislations with regard to the development. Number one, land use regulations. Which land has to be used for what purpose, whether agriculture or non-agriculture. If it is to be converted from agriculture to non-agriculture, or if a particular land is reserved for under the zoning regulations. Who made these zoning regulations? These zoning regulations in earmarking land use for particular land is made under the acts called Urban Development Acts, the development acts which are in force in various states. These development acts, the urban area, they are called urban area, which is notified under that particular act. And for every urban area, the government appoints an urban development authority, and with the recommendations of the urban development authority, the state government issues these zoning regulations, or sometimes they are called as master plan and zone development plans. And these plans will demarcate or show which land can be used for what purpose. And if this land which is reserved for agriculture is to be converted into residential or vice versa, or industrial land, all these have to be, there is a procedure under the act for modification of the plans. What is the significance of these laws so far as RERA is concerned? The other category is, you know, the construction. You need to obtain permission for construction in the land which is reserved for residential purpose or for industrial purpose, commercial purpose, etc. These laws are also binding on local authorities who grant such permission. In case if it falls within the Gram Panchayat, it is the Gram Panchayat. But if it falls within municipality, municipal corporation, like that. However, if there is a development authority under which any of these local bodies also are situated, then the development authority will have overriding powers over this. This is broadly the law. Different enactments are in force in different states, and therefore, though there are similarities, there are also dissimilarities with regard to the powers. Now, the importance of this particular legislation is the importance of these matters pertaining to the land development for the purpose of understanding or implementing the provisions of the RERA Act is that these these authorities are called under the RERA as competent authority. The matters relating to the land or land development, construction, etc., the powers are exclusively governed, the matters are exclusively governed by the authorities under those particular enactments, appropriate authorities under those legislations of the states. The RERA has no control over them, absolutely no control over them, because these persons are called competent authority under the act. So for you to make a development, you will have to obtain those permissions, and you are governed by the terms and conditions of those sanctions of the plans or for the change of land use or whatever. And RERA Act has nothing to do with them. Nothing to do in the sense they have, because even for violation of those permissions and sanctions, the RERA authorities can also take action under appropriate provision of the Act. That means it has a relevance, but it has nothing to do in the sense these authorities have no control over those permissions, only for that extent. But it binds the promoter under the RERA Act, allotting or the purchaser under the RERA Act, and also the RERA authority under the Act. That is both the authority and the stakeholders in the real estate project it binds. So what is the significance? The parliament has no legislative power with regard to the land or town planning, urban planning, or local authorities, but this particular enactment is made in exercise of its power under entry number 6 or item number 6 of the concurrent list. What is that? It is called transfer of property. So the transfer of property means the transfer of property in certain real estate, certain kinds of real estate. What are they? They are, number one, a plot, or that is house site or a plot, or a flat or apartment, or a building, where all these three kinds of real estate should be situated in a real estate project, and that real estate project should be situated within the planning area. What is the planning area? Again, we'll have to go back to the state legislations relating to the planning, town planning, and the permission regulation of building or construction. So that is the importance. If it is not in a planning area, Act has no application. If it is not in a real estate project, even if a plot or an apartment or a building, if it is not situated in a real estate project, the Act has no application. So for the Act to apply, it should be, number one, either it is a flat or plot or building in a real estate project situated in the planning area. What an apartment? The apartments also should be more than 8 or more than situated in 500 square meters. If it is more than 8, even if it is not 500 square meters, it doesn't matter. It applies. Otherwise, if there are only 2 apartments, but in a 500 square meters, then the Act applies. It should be in a real estate project. What is the real estate project? And before we go to it, one thing is this minimum condition, that is either more than 8 apartments or exceeding 500 square meters. This condition can be dispensed with. If the planning authority in a particular planning area, what is the planning area? Like Hyderabad Metropolitan Development Authority or Kakatiya Urban Development Authority or Tirupati Urban Development Authority, these are all, the area is called the planning area, the area under that particular authority, that development area. It is outside, there is a director town planning. In certain matters, he also gets power, because construction of apartments, even in a village, Gram Panchayat cannot grant permission. It has to go to the concerned the director of town planning or assistant director or joint director. Similarly, the layout also, the Gram Panchayat will not sanction. It has to be obtained through the Gram Panchayat only. The process application is processed. Similarly, it is released only by the Gram Panchayat after the sanction. But Gram Panchayat is involved, but it is not the sanctioning authority. So these planning authorities may say that even though they taking having regard to the importance of the real estate project, they may say even if though the apartments are less than 8, still it has to comply with the requirements of the requirements of the act, that if they can apply the provisions of the act. Similarly, this 500 square meters condition also can be reduced or dispensed with by the appropriate government. What is an appropriate government? In case of center, the Delhi, NCR region or Pondicherry, it is the government of India. And in other union territories, it is the Ministry of Urban Development, Government of India. And in all other cases, it is the state government. This is the appropriate government. This appropriate government will make rules under the act, will have to make, not will have to make rules, appoint the real estate development authority and regulatory authority under the act, and has several other functions. Now, we come back to why this the real estate. What is real estate project? The real estate project means any construction of any development of any project meant for the development of the construction of apartments, either by the construction or conversion of an existing building into an apartments, or by developing as plots in a layout or buildings in an open land for the purpose of the sale. That means if you develop the land, not for sale, you may construct apartments, you may divide the land into plots in a layout, or you may construct houses in a project, but not for sale. You may let out, you may use otherwise, or you may distribute among your family members. Then it is not a real estate project within the meaning of the act. That means if you sell an apartment as an apartment, a building as a building, land as a land without any kind of development, then also it is not a real estate project. Act has no application. That means for the act to apply, what you have to do, you have to both develop with an intention to sell, at least if not all, at least some of them. So if you develop without sale or sell without development, act has no application. Both things must be prevalent and existing. Then only the act applies, but not otherwise. So that is the importance of the definition of the real estate project. It is the real estate project definition which contains this. It should be for the purpose of sale. So if you have no intention to sell and no sale, then there is no question of the act having any application. This is the first when the act applies. This is how the act applies. Then we have to keep in the back of the mind to understand this act. The act mainly regulates the sale of these three kinds of real estate products. What are they? Plot, flat, and building in a real estate project. So in regulating the sale, it imposes certain conditions. It imposes certain conditions in the sense you will have to follow certain things. Who are you? One, you are the person whose transactions are being regulated under the act. Number one, promoter. Promoter has a wide definition. Promoter means who develops the land for the purpose of sale, or a GPA holder who does it, or if the person who constructs and who sells are different persons, both the persons, and whether such a promoter is a private person or a development authority or a cooperative housing society or a cooperative finance society or a town planning authority, what even the public or statutory bodies who divide the land for the purpose of sale, who construct and sell, like housing board, sell the apartments or buildings, they are also counted. This is one of the most important aspect of the Real Estate Act, RERA Act. We will come to that. And second, it regulates the sale. Number one, these promoters, one category who are regulated. The second category are real estate agents. Who are these real estate agents? Any person who negotiates or represents the allottees or one of the parties, even the promoter, for the purpose of sale or purchase of these three kinds of real estate properties. He is a real estate agent. Who is the other category? The other category is any person who introduces a lottee or who facilitate the transaction through any media. This is a very wide definition. This is so wide that you just facilitate the transaction, you just introduce. That means by any media, whether it is a newspaper advertisement or a digital application through internet, they come within the definition of this real estate agent. The third kind is allottees. The third kind is the purchaser. Allottee includes a person who has booked a flat or apartment or a plot in a real estate project or a villa in a real estate project, and also any person who has purchased from him. Even a person whose second sale also is entitled to the same rights. He is also an allottee. The word used is not the purchaser, but LOT. A prospective buyer is also included in the definition. That is why the word used is LOT. So the relations between these persons, the transactions of these three persons, the rights and liabilities of these three kinds of persons are very well defined under the Act. That is one of the important features. The most important feature is the regulation of relations of these three players or stakeholders in the real estate project. But it's not as if the other kinds are not regulated. The other kinds of people are also regulated. The rights of the landowners, though not directly, indirectly they are affected. The banks who finance the project are also affected or regulated under the Act. That is also, and the professionals and consultants of the real estate project are also regulated, though they are not regulated in the same manner as the promoters, real estate agents, and the LOTs. How? What is the difference? Number one, registration. How? What is the kind of regulation that happens, that is provided under the Act is by way of registration. What is that registration? Registration of a real estate project, not registration of promoter or real estate or the LOT, but real estate project. If a promoter has got many projects, all projects have to be registered. If the promoter is executing the real estate project in a phased manner, what is the phased manner? He may have 100 acres. He starts with the only development of 10 acres out of it. To start with, he will construct the apartments. And in the apartments, he will obtain permission for that 10 acres only. Then in such case, he will have to obtain registration of only that phase, not the future expansion, which may include villa project or plots, open plots, or a combination of both. So it is for him. But what is the significance of that? The significance is, as I have already said, the Act regulates only when the two things are combined. That is the development and sale. So when you are obtaining permission for construction of only apartment with an intention to sell, you will have to register only that. So a phase also has to be registered. Then what is the registration? Registration of the project with the whom? With the RERA authority. This is the regulating authority under the Act. You will have to get the project registered with them. And you will have to, under Section 3, it is mandatory, unless you have obtained occupancy certificate or completion certificate of the project from the competent authority before the commencement of the Act, you will have to obtain permission. But certain states, different states, including AP, UP, Telangana, Karnataka, several states have, by making some rule, while framing rules under the Act, they have given a different definition to the ongoing projects than what is stated in the Act. For example, Telangana said, if you have obtained permission after 1/1/2017, you don't have to register. But the states, number one, have no power to grant any exemption under the Act. There is no provision for exemption. You will have to only frame rules to enforce certain provisions. And what are those provisions? Where the legislature has left it to the rule-making authority, to any particular subject, to the rule-making authority to make the details. But exemption is not one of them. So, and it is not stated in section 3 in the manner prescribed, which means in the manner prescribed by the rules, which means that it is left to the rule-making authority to decide what is the ongoing project, or what is the definition of it, whether certain things to be exempted or to be added, or whether the definition has to be expanded or to be modified. Such power is not given to the rule-making authority, but the states have done it. Whether the states have got the power or don't have the power, one important principle is that when the act is different from the rules, when a particular provision is contrary in the rules, is contrary to the act, then act will prevail, but not the rule. So by applying any principle, it goes without saying that our act only will prevail and not the rule. So we can close this discussion about the ongoing project. And what is the registration about? The registration has to be made by an application in accordance with section 4. What is the importance of section 4? You will have to make certain disclosures. You will have to make a lot of disclosures while making an application. Who? The promoter who is seeking registration of his real estate project. That is the importance of it. And these disclosures, apart from these disclosures, once the real estate project is registered, the promoter will have to make many more disclosures in the official website of the RERA. The RERA authority will have to allot a page in their website to each of the registered project, and the promoters will have to disclose all the information that is required under the section 4 and 11, and also under the rules. What is the importance of this? The most important thing, because this is one of the most important mode of regulating the real estate project or real estate transactions under the Act. What is the purpose of disclosure? This is transparency. The promoter will have to be transparent. He has to disclose many things, including what is the constitution of the promoter, whether it is a partnership, LLP, company, individual. Then who are the promoters, directors, or partners? What is their experience? What is their background? What is their solvency? What were the projects 5 years? Within 5 years, what are the projects they have carried out? Whether they have committed any defaults, and within what time they want to complete the project. The completion of the project, one is governed by the sanction plan. The sanction plan, which is issued by the competent authority, whether it is municipal corporation, municipality, or the urban development authority or a town planning authority, under the appropriate legislation of the state, those terms may impose 5 years, 6 years, or whatever time. That is not the period which the builder has to disclose here. What he has to disclose here is his intention to complete and deliver. The permission, sanctioned permission for construction may say you have for 6 years you may complete, but he may promise to the buyer, no, I will complete in 3 years. Then it is the 3 years, not the 5 years under the sanction plan. This is the 3 years that matters. How does it matter? It matters because the registration which you apply under section 4 is subsisting, will be in subsistence or will be in force only for the period you have disclosed. It is the 3 years and not the 5 years within which you are entitled to make a construction under the municipal law, but the 3 years which you disclose in your application for registration, that is the period for registration. What is the importance of this? What is see, whether it is 3 years or 5 years, how does it matter? It matters. It matters because if you don't construct within 3 years which you have disclosed, your registration would lapse. It will lapse on expiry of 3 years because your registration is only for the period for which you applied or disclosed. Then if you don't, then what happens? There are serious consequences if the period expires. You cannot say, sir, under the municipal law, I am entitled for 5 years, or I have obtained, though the 5 years time is over, I have obtained renewal from the competent authority. Please permit me. No. The 3 years period, the whatever is the registration period which you have obtained, it is your choice. This is what you held out to the, you have held out to all the purchasers or prospective purchasers or allottees. Therefore, you cannot change it. Nor the RERA authority has got any absolute or power to extend. It can extend to a maximum of 1 year. For any number of times it may extend, but it can't be more than 1 year, number one. Number two, it cannot extend by its own discretion. It can be in an extraordinary situation or in a case of act of God, force majeure, but not for any other purpose. And that therefore the extension, the power of extension of the registering authority or the RERA authority is also very limited. It is not an unfettered power. And if if you don't complete within that period, the registration may also, and you violate the provisions of the act and rules, or if you do not follow or comply with the terms and conditions of the sanction by the competent authority for construction or development, or you violate any of the provisions of the agreement with your purchaser or allottee, then the real estate project, the registration, project registration can be cancelled or revoked by the RERA authority. This is a very important thing. When it whether it lapses on account of the expiry, or it is cancelled or revoked, the consequences are very severe. What are those consequences? The consequences are, number one, you cannot use the page allotted to you in the RERA website, official website. You will be included in the list of defaulters. Your project, and you the promoter will lose the right to complete the project. Who will complete? You cannot complete. You have to go out. You have to exit. And no, there are no rights to you. Well, you might have invested a lot of money. The allottees will get all the priority, all the importance. They have, their association will have the first right to say no, or the first right to carry out the project. That is very important. And the most important, another important thing is, you will lose your right in the over the project. You will be a defaulter, and in the website your name will be disclosed. Your reputation is gone. Your project reputation has gone. And apart from that, under the act, you cannot collect more than 10% without entering into a registered agreement with the allotee. And whatever amount you have collected, 70% of the amount has to be deposited in the separate account with the bank. This separate account is not escrow account as such, you operate, but you cannot withdraw the amount unless it is certified by the architect and the chartered accountant. So it is expected the chartered or engineer or architect only can certify the construction that is made. Whether, and it is the chartered accountant who will have to certify its value, and also whether the amount which is drawn is utilized or requires for the utilization of the project at that particular stage. You cannot withdraw that amount at your discretion. And both the architects and the chartered accountants and these engineers are governed by their appropriate professional regulations, by their appropriate statutory regulatory authority, whether the Institute of Chartered Accountant or the Council of Architects. So they are also subject to certain professional code of conduct. Therefore, they cannot really be irresponsible. And what is the most, and the moment your real estate registration is revoked or expired, you will lose the right to operate the bank account. There may be a very good amount. Your money is also involved, in the sense that you have invested more in the project and you have not withdrawn your due. Still, you lose your right to operate the account. These are the serious consequences that follow. What is the purpose behind all this? The purpose behind registration is, number one, disclosures or the information to the allottee or the prospective allottee or purchaser. What for? And one of the information is not only that you will have to disclose within what time you would construct, but the stages of construction, what permissions you have obtained, what permissions you are yet to obtain, and when you would obtain, whether you have obtained or not, you will have to disclose every quarterly. And not only that, how many plots you have sold, to whom you have sold, and which plot or flat or villa you have sold. All these details will have to disclose. What for? So that no duplicate sales. All kinds of frauds and malpractices indulged by the developers or promoters or builders are sought to be prevented by this mechanism of disclosures and display in the official website. And that is the very purpose of this entire purpose. And another purpose is the purchaser or the allottee shall have a informed choice. He should know what he is going to purchase, what he would get for the money he is investing. And the purpose of controlling even the money, 70% of the money, it is assumed that 30% would go to the land value. 70% is assumed to be the construction value, and this construction money, whatever you have collected from the allottees, should not be diverted for any other purpose or any other project except the project for which you have taken advance. This is the purpose. So this is to ensure that the money of the allottees is not diverted or wasted. And this is to ensure that the builder or the promoter shall not indulge in any kind of malpractice. And this is the purpose of disclosures. No duplicate sales is possible because you will have to disclose. Suppose, in fact, very unfortunately, some of the states have not even framed rules, though under the Act, there is no discretion left to the states. They will have to, number one, frame rules, appoint real estate authority within 1 year from the date of the commencement of the Act. What was the date of the commencement of the Act? There are two. One is with regard to certain provisions, it is 1/5/2016, which relate to the provisions relating to the appointment of the different authorities under the Act. That is 1 year. That is one year from 1/5/2016. With regard to all other provisions which relate to the rights and liabilities of the promoters, allottees, etc., it is 1/5/2017. So the Act did not leave it to the discretion of the states. The purpose of the Act is 1 year they have given for the entire machinery under the Act to be constituted, and so that on 1/5/2017 it was expected that the Act will become totally functional and the authorities and machinery under the Act also becomes functional without any hiccups. But it did not happen because many states have not framed rules. Many states, including Telangana, has not appointed the real estate regulatory authority in the manner required by the Act, and many states have not even created the website. And these things will have to, some people will have to, why they have not created? Because the real estate regulator authority under the Act has independent status. They will get money from their permissions, from their grants, etc. And the appointment has to be made by a committee which is presided over by the Chief Justice of the High Court and not by the state government. And those people cannot be removed by the state government. And these states, the committee has to be, the committee consists of the Chief Justice or the judge appointed by him, the law secretary, and the secretary of the Secretary Housing. And the Act has taken care, even if the state government fails to appoint a RERA authority, then the Secretary Housing shall be deemed to be the RERA authority by default. So it cannot lie in vacant, because the Act deems the Secretary Housing of the state is deemed to be the RERA authority in the absence of the RERA authority being appointed in the manner required by the Act. So in Telangana, because the RERA authority has not been appointed, by default it is the Secretary Housing, who is incidentally happens to be the Chief Secretary of the state. So this kind of authority, this kind of mechanism is evolved by the Act itself to avoid any kind of defaults or delays on the part of the rule-making authorities, etc. The rules are also framed beyond time by certain states. After 1 year, within 1 year, they have not done. Some states, some 3 states have not even framed the rules. And apart from that, what happened is when the Parliament wanted to introduce this Act, the Real Estate Regulatory Regulation and Development Act, the Kerala state has passed its own legislation. And West Bengal, having even notified the draft rules, have subsequently framed its own act, West Bengal Real Estate Development Act. This matter went by way of a litigation by a NGO. That NGO name is People's Collective Efforts. This NGO has taken the matter to Supreme Court and challenged the West Bengal Act. This is a very important judgment in which the what do you call the Act, West Bengal Act, was declared as void. It is declared as void by the Supreme Court, saying that it is beyond the powers of the state government, because though it is framed under the concurrent list, both the state and the union has got power to legislate. But if already there is a central legislation, union legislation on a particular subject, which is an occupied field, then there is no question of, then the states cannot legislate on the same subject unless such legislation is reserved for the president's assent and the president assent is obtained. That is Article 254. In view of that, you have no power. It was declared void. The important thing is, while dealing with it, the court has also taken into consideration several provisions under the Act. In fact, the entire chapter 3 dealing with the rights and liabilities of the promoter are already provided in the state legislations relating to the apartments. So there are more or less the provisions are similar. What are those provisions? That the promoter has to make certain disclosures, furnish all the information and documents to the prospective buyer. He shall not change or modify the plans. He has to make the construction as per the plans disclosed. And if he is making any change, he has to obtain permission from the affected party. If it is one apartment or if it is more than one, then the permission of all the written permission of all the buyers have to be obtained. And the whatever he has disclosed, he has to adhere. He has to make agreement as per the original agreement. He has to execute sale deed as per the original agreement, terms of the original agreement. These are all the provisions which are incorporated under the several provisions of the RERA Act or already there in the local legislations. So these things, these provisions are similar. The court went into this question and also said that all these local legislations relating to the apartments are impliedly repealed by virtue of this article 254 of the Constitution and also section 89 of the RERA Act. So this is a very important judgment for this reason. Now, earlier, there may be some differences between the State Act and the Central Act. The question is, unless there is a conflict, the principle of pith and substance is applied. Which pith and substance principle is applied to reconcile the competing provisions of the central legislation and the state legislation. Now, there is no such requirement. Simply, the court has categorically said all those acts. In fact, they enumerated some, including Andhra Pradesh Apartments Act, saying that they are all impliedly revoked or repealed by the central legislation. So the most important thing now we have to note is it is the RERA Act which only prevails as against the state legislations relating to the apartments. We have to also note these apartment acts have no application to the plots in a layout or villas in a real estate project. Only it applied only to the apartments. It applied, different states had different definitions. Andhra Pradesh and Telangana Act was concerned 1987 Act. It said 5 apartments, minimum 5 apartments. So that distinction is now gone. It is only whatever is RERA says now, because the provisions are similar. There is no point in saying, they even went to the extent of saying repeal. What happens to the other provisions relating to the title in the Apartments Act? Because the Supreme Court said they impliedly repealed, it has to be taken only those provisions are impliedly repealed, but not the entire act. We'll come to that. Now, so far as these rights are concerned, I mean, the importance of this act is, we have discussed with discussed about the promoters' liabilities, and apart from that, the most important thing is, even under the RERA, not only the brochures, advertisements, representations made by the marketing team, but also any model house or model flat or model apartment that is made, that is displayed, if that is not in the flat or part or common areas, whatever are disclosed, are not in consonance with or at variance with those displayed, that is model house or etc., then the purchaser has a right to cancel the booking and seek the entire amount with interest. This is also very important. That is an unfettered right which has without any conditions. Whatever conditions that are made are not valid because it is a statutory right. And what is the other thing? The other thing is 5 years the promoter is liable to may give a warranty in regard to not only the inputs, the goods, but also the skills, and in the construction or in the services that are provided in the property that is sold, whether apartment or the apartment or plot or villa in a real estate project. So, and this is so far as the construction is concerned. How about the land? For land, notwithstanding anything contained in the Limitation Act, there is no limitation. If there is a defect in respect of the, if the if the if the there is any defect of title in respect of the land which is the subject matter of the real estate project, then notwithstanding any limitation provided by the Limitation Act, there is no limitation at all. There is, that means the promoter is liable forever so far as the land title is concerned. The 12 years period limitation is also has no application here. This is very important. So to this, this is where the liability has to be properly cast on the landowner. It is the landowner who has to provide the title. Then to further secure the interests of, we have seen, even in respect of the properties that were sold by the governments in public auction or government authorities like APIAC, we have seen there is a lot of litigation ensued. And therefore, to secure the interests of the buyers in such a situation, what the Act has done is, it has further mandated that there shall be insurance. Insurance for what? Number one, title. For land title, there should be one insurance, and insurance for the construction. But here is the catch. The Act was brought into force in 2016. Act was made in 2015. In 1/5/2016, it has brought into force. It also brought into force certain provisions on 1/5/2017. Though with a 1 year period, with a good intention that everything should be set ready for its proper functioning. But the insurance, which is controlled by the Union government or the Government of India, there is no product in India by any insurance company which provides title registration, title insurance. Title insurance, if there is that is a product that is available in other countries like US, where if it is proved to be defective, the insurance company will compensate, give the compensation. That's a good intention, but the Government of India, which made the Act, also has not taken steps to, and which owns the giant insurance company LIC and its the subsidiaries, has not provided for title registration schemes. So it remained a practical impossibility, though it is legally mandatory. So, and another important thing is, if the title has to be after the occupancy certificate is obtained, you will have to deliver, you will have to transfer the property in favor of the allotee. And insofar as the common areas and amenities are concerned, it has to be transferred to the local authority or the association as may be prescribed under the local acts. If there is a certain, it is provided under the local act, then it has to be given to them. Or if there is no provision, then it is to the local authority. This is how the the act also provides certain important liabilities on the part of the buyer also. This one important thing is the agreement between the mandatory agreement between the promoter and the allotee has to be registered, but it has to be in the prescribed form. What is the prescribed form? The form that is prescribed by the state government along with the rules, under the rules. So you can't avoid, you can't make one-sided agreement. Apart from that, it should be in the prescribed form, and it has to be registered, and the conveyance has to be made in accordance with the terms of that agreement. And the buyer, there is a payment schedule in that. It is mandatory under this prescribed format to disclose what is the actual carpet area and what is the other areas. It is not stated in the act that you should not charge for common areas. You can charge, but you must disclose. The buyer should know what is the actual carpet area and the other areas like common areas and amenities which are being charged. You need not load the entire price on the carpet area. Under the Telangana rules, it is made clear also. All that you have to do is you have to make it clear. How? You have to make clear about the breakup of the price. What you are charging for the price, what you are charging for amenities, what you are charging for the taxes, towards taxes. Everything should be made clear, and there must be payment schedule. And the buyer has to make payment as per the schedule. If the buyer makes a default also, the promoter has a right to cancel it. And if the buyer or the allotee feels that the cancellation was unreasonable, then they can go to the RERA authority and make a complaint. The RERA authority may take make appropriate decisions. Both the landowner, promoter, and the buyer has got similar rights with regard to interest. Whatever is the rate of interest that is liable to be paid by the buyer or allotee is the right. In case of default, the allotee also will have to pay to the promoter. Promoter has to take possession within 3 months from the date of occupancy.